I don't forget, and I'm going to change the presenter keys to Rebecca. And hi, Rebecca, are you there?
I am,
All right.
and can everybody hear me? I guess so.
I can hear you. Thank you. You sound good.
Great. Okay, please show your screen. Okay, I've just showed my screen. I assume everybody can see it, so we will begin. And
Looks
first of
good.
all, I want to thank you. I want to thank everybody who is attending or who is interested in this subject. It's certainly a subject that I've been studying for the last 20 some years, and copyright, and I'm just thrilled that people are interested in it because it's something that I think we all need to know. Um, Before I start, I will just say that I asked Louise, I told her I don't mind if there's a question that really needs to be asked at a particular time to let me know. Otherwise, we'll probably tend to save more questions toward the end, but if there's something you just really have to know, she certainly can let me know and I will answer it during the presentation. And I will leave time at the end for us to discuss things too. Anyway, I entitled the presentation That Thorny Issue, Copyright Basics and Interlibrary Loan because anything dealing with copyright, at least in the United States, tends to be a thorny issue, as I'm sure some of you realize as you've been working through the process and so on. So everything I talk about today will be in the context of interlibrary loan. That's the way I'm looking at this. However, if you have other questions, if it's something that I can answer, I'll be happy to answer them toward the end of it or whatever. So anyway, I was told that there are school librarians, public librarians, and academic librarians in the audience, so I will try and give a sort of broad overview of things so it fits for all of you. And what we're going to do is look at interlibrary loan, and within that, copyright basics for print and digital specifically, and also analog for some of those older items that we may have. We'll look at open sourcing and then obviously answer questions as applicable. What I'd like to do, I've already explained about posting questions and so on, and as time permits, we can just keep talking and discussing. The other thing is I will make this PowerPoint is going to be available to you all as well as the handouts, and I do have two on the first screen, which I've already skipped by obviously, but I have my email addresses. So I've got two emails. The one I just retired from Northern Illinois University a couple months ago, so I've got that one. And then in February, my new address or the second email will come into being. So I'm just pointing that out because if you do have a question that you think about later, if it's something that I can help you with, please feel free to email me and I'll try and work with you with that. Okay, so interlibrary loan. Okay, the first thing when we think about it, we know that it basically is, and you all are knowledgeable in this, so this is just sort of an overview to get us going, but in the borrowing or copying of an item for use by someone, an individual or a library at that requester who needs something but they don't own that work. It's not accessible to them in their own library. So there are a number of things, and usually there are things that are either too expensive for every library to own them, they're difficult to acquire, there's something that isn't needed all the time, whatever. Does copyright affect every bit of interlibrary loan? The answer I would say is yes. Copyright law will be in play whether you realize it or not. Now, in today's world, it's most common that electronic delivery is used for much of interlibrary loan. However, it still could be the quote-unquote older delivery where you send it to a central office, let's say, and they ship it out in a truck or whatever. It could be through mail or another way. So there are lots of ways that you can get your interlibrary loan. And ILL is truly about the distributing of the material, not the copying of it. But the issue really comes into play in today's world because so much of the time with electronic delivery, what's happening is it's being copied. So there is quite the concern here. Okay, with electronic interlibrary loan, we often see a library, they're transmitting a scanned copy to another library, let's say. So there is a requester at the first library, a patron who requests something. The librarian finds out where, or someone, whoever is working with interlibrary loan, finds out where that material is accessible, where it's available, and requests it. So now the other library, the lending library, is tasked with usually doing something like making a scanned copy or in some way a copy of it and sending that back to the requesting library, and who then gives it to the patron. What happens with electronic interlibrary loan, as this slide talks about, is you've got these scanned copies, and in reality, it is feasible that either the lender or the requester could be liable if there's a copyright issue. The supplier could refuse to copy it, and that electronic reserves can also come into play because it could be that whatever's being lent goes into an electronic reserve. So there are lots of things that we're going to look at in the next hour and a half or so. Okay, so the positives, obviously, of electronic or digital delivery for ILL are things like the speed. It can be done very quickly. The ease of access to the patron who might be receiving this item through email or some sort of an electronic box or through a database or something like that. So there are a lot of things that are going on, and these are the positives. But there are negatives, and especially in terms of copyright law, which, by the way, copyright law, as I will explain in a little bit, is a federal law. It is sort of overriding, and within the United States I'm talking about it now, but I will also touch a little bit upon international law and how that might affect you as well. But the negatives of electronic delivery are the fact that more than the copies that copyright law says are legal could be made during this process of moving that item from one library to another, especially electronically. So what you have is the copy at the lending library. Let's say it's a print item, an article out of a journal, a very obscure journal that's very expensive and only a few libraries purchase it. Okay, so you've got the copy in the journal. We'll say it's in print. Then you've got the scanned copy that the lending library has on their computer because they've scanned it so they can get it to you. Then you've got the copy on the library computer of the receiving library. Then you might have that copy that the patron receives via the internet. And the patron might decide to print that copy out. So they've got it online, but maybe they print it out for their use. So there's another copy. Then let's say they decide to share it with somebody else because they feel the need to do that. Maybe that's, let's say it's even with one other person, one more copy. So instead of that one original copy, we've got 1, 2, 3, 4, 5, 6, at least 6 copies. This is where copyright law starts to have some issues. So what to do? Okay, let's go on. Let's add copyright to this mix of interlibrary loan. To be copyright protected, the item must be fixed in a particular medium of expression. That's what I pulled this from a particular author, but that particular bit of information is built into copyright law overall. So what that means is it has to be in a certain format. But if you think about it, almost anything that is from a creative mind can be copyrighted. So it's not just the magazine article or the book or even the web page or the software or the movie. It can even be things like modern dance, like paintings, statues, etc. All kinds of things can be copyright protected because they are something that came from a creative mind. So in addition, architectural items, buildings, whatever, all kinds of things can be copyright protected. And obviously this particular slide, I've listed some of the more common ones that within your particular libraries or your environment you might be possibly working with. So I would say that it seems like one of the most common ones deals with print, with journal articles and things like that. So we'll be talking about that a lot, but remember that there are all these other things as well. Okay, copyright law itself is a law open to interpretation. This is part of the issue with this law. It's kind of interesting because when the first people in the United States to create, well, basically, we have to go back further than that. Our idea in the United States of copyright law actually comes from England in the 1700s and what's called the Statute of Anne. So that's where our concept of ownership by an author or owner of a work comes from, and so on. It was brought to this country when the different groups came to this country. The concept of ownership of creations came with it, and we first see it in the U.S. Constitution, a mention of that. But within that, what we find is this is a very controversial subject. The law is written in a nebulous manner so that there can be many interpretations. And as we go along, I'm going to talk to you about the interpretations of the law. Basically, though, what you need to remember is that, yes, individuals can be liable for their own actions. If the case goes to court, if legal action is taken, the final decision is the court. And I always have this in my presentations, and that's don't shoot the messenger. In this case, I am the messenger, and what I'm going to give you are the most common interpretations of the law in terms of interlibrary loan and the use that you're going to have with it. Okay, so what we're going to do here with copyright, and remember this is all within the umbrella of interlibrary loan now, we're going to define it, look at a little bit more at the history, look at statutory provisions, public domain, asking permissions, license, and guidelines. And within that, I will weave in interlibrary loan. So first, let's define copyright. There are four basic sort of premises of copyright law. It's the right to reproduce or copy a work, the right to prepare derivative works, the right to distribute that work, and the right to perform or display it publicly. Now, there are two main points for those of us as far as, and I'm sorry, I seem to have, oops, I'm going to leave that be. And we're going to move back. Sorry about that. It looks, I think my email that I thought was turned off just made a noise, so please disregard that. I apologize. Anyway, there are these four things, and basically two of them are really connected with interlibrary loan, and that's the right to reproduce or copy a work because we might be creating other works, and the right to distribute it. But any of the things could be involved feasibly within interlibrary loan. So who has all these rights? Well, normally the author or owner of the work has the rights. And I'm saying one or the other because the author or creator of the work does not have to be the owner of the work. For instance, I could, and in fact, a few years ago, the American Library Association asked me and another woman to do a basically a monograph. It wasn't on copyright, it was on a different subject, but they asked us to do that. They paid us to do that. It was called work for hire. So we wrote and created this particular monograph. But since the American Library Association had hired us to do it, they own the work. So they are the owners of the work, and they will and have determined copyright for that particular work. So the owner of the work is doesn't have to be the one, obviously, that created it. They could have paid somebody, or they could have had it given to them, or they could have bought it. For instance, the Michael Jackson estate owns a lot of Beatles tunes because I think it was while he was still alive, he purchased a number of the tunes, and now they become part of the estate, obviously. So the Beatles don't own them. Michael Jackson's estate does. So within copyright, there is this right to make copies legally and to change the work and then make another copy, to give it away or to sell it or whatever, or to put it out in the public eye. So lots of things. So the main focus on this presentation rests with the right to reproduce and copy, and also to a slightly lesser extent to distribute, but like I said, any of them could work. Okay, the history of copyright law. The first mention we have of it in the United States is in 1790 in the U.S. Constitution, where there's basically a short paragraph stating the fact that people who create items have the right to make money off those items or give them away or whatever. Within the law, there have been a number of revisions to that first statement, and they were two in the 1800s, as you can see, and two in the 1900s. Interestingly enough, in 2015, the base law we are still working with is from 1976. What has happened is all the additions to update the law have been just that, additions or acts that are added onto that base law from 1976. And what that means is that almost all the time, copyright law is a couple of steps behind whatever the technology is at the time and is racing to catch up. You can see that in 1998 there's the Sonny Bono Extension Act. In 1998 there's also the Digital Millennium Copyright Act, which even mentions interlibrary loan. There are some other acts as well, and all of these have been basically added to that base law. And as we need to work with them, I will talk a little bit about them. So what usually happens with copyright? Well, what usually happens are that users of works think the laws and guidelines are overly restrictive. They want things freer and so on. But the owners of works tend to think that they're giving away too much. So this is always a dilemma. And in a library, you all are somewhere in the middle, because you're working with both the patrons or the users and the owners of the works. You're working with both groups. So you're caught somewhere in this middle. And basically it can be a less than comfortable place to be. So we're going to talk about ways that you can work through all of this. So if you want to legally borrow or copy a work, and remember, there's a good chance you could be copying something with interlibrary loan. Some of the things are to use the statutory exemptions, which I'm going to talk about in a minute, and they are basically pieces of copyright law, to use guidelines, to use original work, if it's yours, let's say, and you know you can give it away, but seldom are you going to need to interlibrary loan your own work, probably, to obtain permission or a license, or to find something in the public domain. And I will go through these now a little bit so we can look at them. But before I do want you to look at this slide that's coming up. It's called the first sale doctrine slide, or that's what I'm calling it. And the first sale doctrine is something that is part of copyright law, and it says that you or your library has purchased a particular item. However, that is not the right to copy it indiscriminately unless you purchased a license to do so on top of that or as part of that purchase, or if it was given to you as part of that agreement. Sometimes this means a bit of confusion when you're working with interlibrary loan, but basically it means is you've got that one item. In the old days before electronic interlibrary loan, it was easy. If I had a book and somebody in Bolingbrook needed that book, you would contact me, and maybe through the mail or through a truck or whatever, the book would be sent to you, and you'd have it for so long in Bolingbrook, and then you would send it back. So there was that one item. It was easy to deal with then. Now that we're making all these other copies, it's not as easy in that respect. Okay, so statutory provisions are points that are written into the law, and if you can follow these points or these pieces of the law, your chances of basically within your work environment or in the helping of the patron of breaking or stretching copyright law has gone away. So basically what statutory provisions do is they help us find ways to borrow or copy things without infringing on copyright law and without needing to obtain permission, which is another issue that can be difficult sometimes to do, because obtaining permission means you're going to ask the owner of the work if you can use it in the manner that your patron needs it used. Borrow it, copy it, whatever. Sometimes that's easy to do, to find that owner. Other times it's not so easy. Okay, so the most important statutory provision, and one that I'm sure all of you have heard of, is called fair use. This is, no matter what you do, the most important one, but for school, public, and academic libraries, definitely this one still is going to be the most important, especially if you are in the public, i.e. you're a public library. If you're a public school or a public institution of higher ed, then this one really stands out as something that will be helpful. And there are 4 factors. What they are is, within each work that is being borrowed by the requesting library and being sent from the lending library, you have to think about the character of the use, the nature of the work, how much, and the effect on the market. The character of the use. How is it going to be used? If it's going to be used for an educational purpose, i.e. a student or a teacher has need of this, that always tips in favor of fair use, so that's a good thing. Nature of the work. Is it fact or fiction? Published or unpublished? Okay, I'll just tell you that for whatever reason, the law likes factual published pieces best. So it's easiest to borrow or lend via interlibrary loan or whatever information or materials that are nonfiction and published. With copyright law, it is possible, obviously, to borrow fictional pieces, but the law leans toward the favoring nonfiction for whatever reason. Now, unpublished is a little hard in the way it's defined in today's world, but there was a time that one could argue that if they found, let's say, a letter that George Washington wrote to Martha in their basement or whatever, that would be an unpublished piece. But those are a little harder, but it's pretty uncommon in today's world, so you can pretty much forget that part. Okay, so that is the nature of the work. Now, how much? is measured both quantitatively and qualitatively. Quantitative, we all get. How much, how big, how much of an amount is being borrowed or copied and sent to another library. 6 pages of that print item, the entire article, the entire musical work if it happens to be a piece of music, a score, or if it happens to be something in an audio format. The other thing, however, is there is a qualitative measure within copyright law as well, and that is if you borrow or wish to have the heart of the work, borrowing it or copying it might be too much. Now, the issue here is the might, which is a bit of an issue. I know, I realize that. What that means is that the heart of the work, that piece that everything draws together to. So for an example, let's say there's an hour-long movie called The Kiss. Okay, and everything builds to a 30-second kiss. Okay, everything in that hour. If the owner feels that that 30-second kiss is so important, that's the heart of the work, the owner can say that for permission for that piece, there has to be that you have to have a special request or whatever. So that can be a possibility. So the how much does have a qualitative and a quantitative piece that can come into play in fair use. The last one is the effect on the market. By borrowing or copying that piece and sending it somewhere else, are you making it so the owner of the work will not get as much money off of that? And that can be an issue too. The law says that everybody who copies or borrows a work is supposed to follow all 4 of these factors. Now, what we know is through different legal actions that have been studied over time, oftentimes if 3 of the 4 are hit, that is okay. But again, that would be something that would be determined if this ever got to the point that it was going into a legal action or through the court, which probably will never happen with hopefully with what we're working with today. Okay, there are some selected fair use URLs that I just wanted to briefly pull up and let you look at. Fair use checklist is one, and it's kind of interesting if you look at it. What it does is within fair use, you can click on opposing fair use, favoring fair use for anything you're working with, and it's going to give you an idea of what, how the use was, if it would work or not. How do I know if my use is a fair use? Is a wiki spaces one, but there is some interesting information where you can look, ask questions, read the form, and so on. Again, these are just some things online, and there are many things online that can help you. So some things to play around with in the future when you're, thinking about it, to give you a little more information. The exemption, or that piece of law of most important to us today with interlibrary loan in mind, is probably the library exemption, other than obviously fair use that I've already talked about. The library exemption is called Section 108, and this section of the copyright law talks about how libraries can copy work, including for interlibrary loan use, without violating the law. And these are for many different reasons. Other reasons might be for preservation purposes, for private study, but obviously also for interlibrary loan. So the library exemption is another good one for you all to be aware of. Basically, with the library exemption, what occurs as far as interlibrary loan is that, as it says here, qualifying libraries may send portions of copyrighted works to other qualifying libraries as long as that aggregate quantity doesn't replace a purchase of or subscription to the work. So if you want the entire subscription for a particular year for a journal, probably that's too much. But if you want one article out of one journal, you should be fine. Do note that, like copyright law in general, Section 108 of copyright law never defines what an aggregate quantity is. Instead, it leaves it to the librarians, so to those of you requesting, to those of you lending, to interpret the spirit of the law. This happens all along with copyright. It isn't just in terms of this particular section, the library exemption section. It happens all over within the law, which is a bit of a frustrating thing. It does keep us as librarians on our toes. So if you are that lending library and you are being asked to lend something, and so this is whether it's a single copy in the library or something you're sending off to another library through some form of interlibrary loan, that your library needs to be open to outside researchers, that the copies must have no direct or indirect commercial advantage to the patron or either of the libraries, and there needs to be a copyright notice placed on each of the items sent off. So if you do scan that article, let's say, we'll use that again as an example, that means that the copyright notice for that article needs to be on the front of that scanned the first page, or it could be on the last page. Honestly, it never says where. It could be in the middle of it, but you need to have it somewhere where anyone who would ask could find it. So it needs to be there. There are limits to the library exemption, and these are that except for preservation purposes, libraries are not supposed to copy things like video, software, etc., except if you copy an article and part of that article is that there's a picture, a chart, a CD, or whatever involved, then that can go with. So again, as with most of copyright law, there is not just one answer. It's not yes or no. It's shades of gray, smoke and mirrors, whatever you'd like to call it, but there are exceptions to almost every rule. And so I would tell you that one of the things to do is always follow it to the best of your ability, but then, you know, be conscious of what's going on, ethical, etc., in working with this stuff. Okay, another thing the law says is if something's in the public domain, then you can do with it whatever you want. Then you could send copy after copy all over. You could keep it on your hard drive. If you have something in the public domain that someone else wants and they can't get it, there's no problem then with copying that at all, because the public domain obviously means it's open to everyone. It's materials that are not under copyright protection or have never been. Now, again, in 2015, you're not going to find something published in this year or any of the previous years for quite a long time that's never been under copyright protection, but you will find things that are out of copyright protection for one reason or another. So here are some examples of public domain materials. Works never copyrighted. I said that's uncommon in today's world, but it is feasible, i.e. if it's something that was done in the early 1920s or before. At that point in time, any time before, like about, let's say 1922 or whatever, you could make a choice as to whether you registered it or not. So it was possible. Some of these older items, it's possible. They just never were copyright protected. But also, there are some things that cannot be copyright protected. Now, earlier on, I talked about all kinds of things that can be copyrighted, but there are a few things that people have tried to copyright and to own the work, let's say, that can't be. For instance, nature, You can't copyright a tree. I know that sounds weird, but believe me, if you study it historically, people have tried. Yes, copyright trees, yes to copyright, you know, scenery, things like that. Things like that cannot be copyright protected. There are works with expired copyrights, and there are works for which no one claims ownership, which are called orphan works. Um, Sometimes orphan works are in the public domain as well. Not always. We will talk in a little bit about how you can determine that difference and how that works. Um, so there are And also, there are things that people put in the public domain. So I might create that video game that I would love everyone in the world to be able to use any way they want. I can give it to the world, so to speak. If I put a statement on it saying, I created this, this is in the public domain. Now anybody can use it any way they want. So it is feasible that there are some things that people have just given to the world as well. Okay, so if it's public domain, anybody can copy anything. Anybody can, so you could send interlibrary loan like crazy. Some of the stuff that we know is in the public domain that you can be pretty assured of is almost all federal documents are in the public domain. Not all. Again, there are always exceptions to every rule, but for the most part, if a federal document does not say that it has a copyright notice on it, you can assume is in the public domain and just copy it as much as you want. Otherwise, you need to think about other rules. For instance, anything created January 1st, 1978 or after is owned by either the author, creator, or the owner of the work for the life of that creator plus 70 more years. Or if it was work for hire, like what happened with me with the American Library Association and that monograph years ago, 120 years from creation. So I created that in the 1990s. So sometime, okay, in 3000 something, it will go in the public domain, and I will have, obviously I won't be around then, but that won't be any use to me, but that's when it'll go in. Before 1923, pretty much anything copyright protected in the United States, anything published before then is in the public domain. From 1923 to 63, things can be in the public domain, but they can also be renewed for another copyright protection period of 67 years. This is because as the law evolved, there were time periods when copyright protection ran out sooner, and so the law was changed to add on more years if owners wanted. Then from 1964 to 1967, there's this 28-year first term with an extension of 67 years. Now, this is obviously complicated. I'm not expecting you to remember it, but one thing you can do is go to this copyright slider, which hopefully will be popping up here in a minute. Yep, here it is. And so as you can see right here, it says if something was published after 1923 and before 1978, and if it was published without a copyright notice, is permission needed? The answer is no, it's in the public domain. But let's move along. And let's say it was published before 2003 but after 1977. Is permission needed? Look at that answer. Maybe. And what is the copyright status / term? Protected through 2047 or longer, i.e. the life of the author plus 70 years. Remember, we talked about that. So when you get a maybe, then it's possible you might be having to ask for permission to use the item, which in some cases might be to in certain cases to even interlibrary loan it somewhere. That all depends. Okay, the Digital Millennium Copyright Act is another piece of the law that attempts to address some of the digital issues, and some of the more important ones have been things dealing with anti-theft devices, i.e. digital rights management, and the liability of internet service providers. But the DMCA also talks with a little bit about interlibrary loan, and within that, how you can work with electronic things. So, and that's some of the stuff that we've been talking about as we're moving along. Another thing, it's actually peripheral to interlibrary loan in some ways, but is that of permission. And that's, if you get a request, who would it be the lending library or the requesting library if there was a need to ask permission of the owner to send the work? Well, one could argue either one, but probably the lending library, let's say. And if you had to ask permission for someone else to get the work, that would mean either asking the owner for the work, purchasing a license which said you could make copies and send it somewhere else, using a clearinghouse, or and if nothing else, making sure that the work is cited correctly and so on as it's sent, has the copyright notice on it, etc. Now, this is important. It is peripheral in a lot of ways to interlibrary loan, but what I will tell you is, for instance, the Copyright Clearance Center, and there are other organizations like that that operate as clearinghouses, and they can help libraries if there is something that they want to send via interlibrary loan and there is an issue with it. They can often help you find the permissions, obtain the permissions, and so on. Now remember, most clearinghouses do charge. That's how they're earning their money, obviously. So that would be an issue, and with that in mind, places like the CCC, for instance, are more likely to work with public or academic libraries because they have more money than school libraries. Okay, another thing that may affect interlibrary loan would be that of licensing. Licenses are that legally binding contract between two parties. What it's important to remember is that a license will supersede copyright law. Licenses are considered state law. Copyright is federal law. In most cases, state law will supersede federal law. So the bottom line is, if within something that a lending library has purchased, they have purchased a license to use an item in certain ways. If there is a request to interlibrary loan that item or an electronic version of that item, then you have to follow the license, not copyright law. Which the license may be broader than copyright law, giving you more abilities to do things, or it may be more strict than copyright law. So basically, with that license, the owner of the work has granted specific exclusive rights to the library who owns the item. It will be normally part of the documentation, and I would tell you that those of you working with interlibrary loan need to have an idea of how the library owns a particular item, if there's a license involved or whatever, because you will need to check with that to see what you can and can't do. And it is possible that when a library goes to purchase a particular work or item, that they can negotiate in the fact that it may be interlibrary loaned and other such issues when they're purchasing that license. Just to give you some examples of licenses, what I've got here are some examples of software licenses. I don't know how often people interlibrary loan software, maybe not very often, but just for an example of licenses, there are three kinds for software: click wrap, browse wrap, and shrink wrap. Click wrap is when it's online and it pops up and you're supposed to read it and then click out of it. Browse wrap is when a statement pops up online, just the statement saying, if you want to read the license, click here. Shrink wrap is sort of the old-fashioned way, shall we say, when we were purchasing software from the store, let's say in CD form, and when you opened up the shrink wrap, that meant you were now adhering to whatever the license was. That's the shrink wrap license. So that gives you some examples of licenses as far as software, but again, within any item, it can be licenses. For instance, I'm sure a lot of you work with databases, and most databases, when you purchase them, you purchase a certain amount of time to use that. You may purchase the ability to either print out articles, the entire article, or just the abstract. You purchase different things. Those are licenses that you've purchased. Okay, guidelines. So we've looked at the law within statutory provisions and all these other aspects and things dealing with licenses and things like that. Now let's look for guidelines. Guidelines are often used within interlibrary loan because they're easier. Arguably, guidelines are considered congressionally created in that Congress has agreed that if people follow the guidelines, they probably will never have a problem. However, the guidelines are not law. They're just helpful when trying to abide by or interpret the law. Thus, guidelines are not binding, but they do mean that the users, the borrowers, and the lenders have been considered to have acted in good faith. Guidelines also represent minimums rather than maximums, which means that you can follow a guideline, it may work, you may be safe, chances are you could probably borrow more following the law. And I'll give you some examples. For instance, it's very common to consider the 10% rule. This is if I borrow or copy 10% of an item, so in this case you're sending it to another library or whatever, then it's going to be okay, that 10% rule. Okay, that is a guideline. It works in a lot of cases as the fair use guidelines for educational multimedia. Those are sitting up there. However, in actuality, chances are you could borrow more than 10%. But if you borrow 10%, you're probably going to be safe. We talked earlier about the library exemption, and there were several print guide things going along with that. The print guidelines are almost the same as what we talked about before, that you can make single copies of the following, like a book chapter, a magazine article. And that if you make more than one copy, and that you need to put the copyright notice on, and so on. However, this particular the 3 print tests that I'm saying that are needed to follow here, those are all guidelines again. So brevity, copy the smallest amount necessary. Spontaneity, it's got to be a last minute thing. There's no other way to get something. Cumulative effect, it's only got to go to a certain point, or you can only borrow like 3 or 5, which we're going to come to in a minute when we talk about the rule of 2, the rule of 5, and so on. If you're working with DVDs, CDs, videos, movies in many formats, there are other restrictions involved as well that say you are not to only you know, that you're not to send pirated copies of things. It's common sense that you aren't just supposed to send the audio track or change a format from a video to a DVD to send it, that kind of stuff. So that's more or less the common sense. The same holds true with software, which looks at things, again, as we've talked about, like archival copies, licensing, and I would always say if you have licenses, keep a log of that stuff. Policy, you may have a library policy code or an ethics code of some sort, always follow that. Since these are less common, I'm just going to sort of skip by them a little bit. You can ask me more about them later. Do be aware, even the internet, which I don't think you'd be interlibrary loaning, except you might use it for the interlibrary loan, but just as an FYI, you treat the internet and stuff you find on the internet pretty much the way you would anything else. So acknowledging copyrights, fair use, using copyright law, the public domain, etc. Now, digital media, we're working with that a lot, includes things like internet-based communication tools, our social networking tools, video streaming, web syndications, so on. There can be all kinds of things going on. So when I talk about that, keep that in mind. So with all this, you need to consider the law, things like the DMCA. With digital media, you need to consider those digital licenses, and there's something called open sourcing. You need to consider the copyright policies of the lending library and the borrowing library, and more. I already talked about the DMCA. This is just that same slide again where I mentioned that it does cover some of interlibrary loan. But basically what the DMCA is doing is telling you, the user or the library, that when you're sending something, using something, trying to obtain something, whatever, that is needed, that you need to follow the licenses. You need to abide by copyright law and the notices. If their licenses say to limit access, put a statement on there that this is for the borrower's use only and no one else, if that's what the owners of the work request. And if it is something you're using for a class, at the end of that class term, terminate it. Okay, a couple of other things. I've been talking about licenses and open source. What is open source? Open source means that the owners or creators have given the public the right to share and create a new work using their work without fear of copyright violation, or to do some part of something. Open sourcing, those are really licenses where the owner of the work gives certain permissions away or requests certain things of the users of the work. So it's sort of like public domain, but not exactly, because you don't have to give away everything. If you've created that item, you can give away some stuff, but not everything. So, and I won't go into these links because I see it's 5 to 3, and I want to get to some questions pretty soon. But these are a couple of sites. Creative Commons, you can do Creative Commons licensing if you're a creator of a work. GNU is another one that can be used, and there are different licenses. And I'm not going to use an article for an example this time. Let's say it's a video game. If a video game were given some of the certain Creative Commons license, perhaps it would be given one where the owner would say, okay, you can borrow my game, you can create a new game, but you can only, you must keep my scenery the same, or you must keep the sounds I use the same, or whatever. So the owner of the work is telling you what you can and can't do. So it's a type of license. Okay. There are also copyright policies that I would guess every one of your institution has a copyright policy. And most of them do talk about interlibrary loan. Usually within the copyright policy, you're going to find things like follow the copyright law, follow the rule of 2, follow the rule of 5, follow reproduction of copyrighted works by educators and librarians, things like that. Okay. What are some of these things? We've already talked about the law, so let's look at the rule of 2. Within the law, within section 108, so we're still in the law, libraries may provide one article, one per issue, per patron, without requesting copyright permission. So if it's just one article of one particular journal for one patron, that can be sent without asking for permission from the owner, without any other worries. However, if there are second or more copies, then the librarian is supposed to request copyright permission and pay royalties and so on if needed. So that's the rule of 2 in a nutshell. We're going pretty fast here. The rule of 5 is for periodical articles, and this one I'm sure that I would guess a lot of you are following. Basically what that means is that the borrowing library can receive copies of up to 5 articles from a single periodical title, not one issue but the title, per calendar year. So they can borrow up to 5. It's that 6th copy that means that now you may have to get permission, pay royalty fees, and so on. And basically, the borrowing library and probably the lending library are going to have to consider whether the copies requested would substitute for a subscription or the purchase of a journal or whatever. Now, the rule of 2, the rule of 5, all of these that I'm talking about, these are all guidelines. Remember, they aren't law. Well, oops, I'm sorry. The rule of 2 is part of the law. The rule of 5 is a guideline. It's one that if you follow it, probably you'll never have anyone say, hey, you borrowed my work without permission. You sent it to another library or whatever. You requested it. You got it from another library, whatever the case may be. Now, if this is some other information about the rule of 5 for other materials, we've talked about an article. If it's a book chapter, let's say, then it's feasible that that if it's more than that small portion, that with that 6th copy, with that 6th chapter, whatever, that royalty fees may be required. And again, you'll notice that every time the librarian must evaluate whether the copies requested would substitute for purchase. So that could be the lending librarian, or it could be the person at the receiving, could also be doing that as well. That is an issue to consider because the law, remember, is nebulous. It means you have to decide and hope you're making the right decision. And that's based on your knowledge, on the knowledge of your colleagues, on the policies within your institution, and so on. Also, if a work that someone wants to borrow, let's say a chapter from, or an article or whatever, is more than 5 years old, then the lending library determines the appropriate copying. Okay, so these, remember, we're talking about guidelines there. The rule of 5 is not part of the law. The rule of 2 is coming from the law. Okay, so some more things to consider. Include the copyright notice on interlibrary forms. Place the copyright date of the work on all works sent to the requester. Interlibrary loan, according to the law, is supposed to focus on research, scholarship, and private study. And interlibrary loan copies are for the patrons, not part of the requester's library. So if you receive something as the requester, now you're supposed to send it to the patron, but delete it off your hard drive. Most of your libraries will have some sort of policy as far as interlibrary loan goes, so retain all records within that policy. If there are limits that are exceeded, then you need to check as to whether you need to pay royalties, ask for permission, etc. And remember always to transmit the copyright notice. And it would be helpful to also have a copyright compliance statement also that was transferred. Okay, just briefly, international copyright. the United States does belong to a number of conventions and organizations with lots of other countries, and some of those are listed here on this slide. What happens is that, and this is sort of a generic thing I'm going to tell you, well, there are exceptions. The normal agreement between the U.S. and other countries is more or less to the effect that anything used in your country will go, you'll follow your law, and anything if it's used in the other country will follow their law. Because copyright laws aren't the same in all the different countries. What this does mean, however, that there are times when you're working with international items that something could actually be in the public domain in one country and in under copyright protection in another. So if you're borrowing internationally, it would be helpful to be very careful. And I also, within the second handout, have a brochure that will give you more information on that, one of the pieces in there. The other thing you can do is also consult on looking at the U.S. Copyright Office website, or you can contact the U.S. Copyright Office, and they will at times work with you. If they are working with you to find out about copyright or ownership information, they too usually charge, although not as much as a Copyright Clearance Center or other clearinghouses. Okay, another thing to think about is within all this, if there is infringement going on, there are three kinds: direct, contributory, and vicarious. Direct is the direct infringement, so copying illegally or whatever. Contributory is when you help, and that is probably the one that people working with interlibrary loan are most likely to get involved with, because you are sending something to someone else, you are receiving it and giving it to a patron. You may be in that process of helping someone else get something in an illegal manner. Vicarious is when, let's say, your supervisor, your administrator tells you to do the copying and you feel you need to do it. So those are three types of infringement that can happen. So bottom line, whether you're doing interlibrary loan or something, or in some other way copying a work, ways to avoid it include following the law, obtaining permission, going to an attorney if you need to, encouraging people to read the documentation, reading it yourself, trying to remain up to date. Obviously citing what you quote. I put it in there because it's of use to your scholars that you're working with. It won't make a difference for interlibrary loan, but you do want them to cite. Or obviously don't copy, which is, well, a good word defeats the purpose of ILL. Okay, so bottom line, we are liable for our own actions. Okay, and at this point, I would like to open it up for questions and discussion. And if there are not a lot, then I will move along to some samples that I have myself. But I will first leave it open. Louise, are there any questions?
So far, we do have a couple questions. Let's start. I'll start with the first one. Would Section 108 cover the duplication of VHS video cassettes to DVD? Suppose the patron can't use the earlier format. Could the duplicate be loaned?
Okay, so the patron can't use the VHS format, let's say, and is saying, could you put it into a DVD format and send it to me?
Right.
That's the sort. Okay. Well, the answer to that is maybe, and let me explain. Every single format like that where you're converting it to another one is going to have to be taken by itself. So it will depend on, for the lending library, did they purchase a license that they could do such things to it? If they did, then it's no problem. If they did not, then they're either going to need to obtain permission first from the whoever they got it from. So from the owner of the work, let's say, it would not be the vendor, but the owner of the work. Or it would have to fall under some other sort of use. And let me explain a little further, because I know this is complicated, but basically what's going on is the law, copyright law, in a case like that, wants whomever wants that particular movie, let's say, to go out and buy it. So if it's available, if you have a VHS version in one library and another library is requesting that copied to DVD and sent to them, if it's available in a DVD version, what's happening is the law is saying you're supposed to buy it unless you cannot afford, let's say, to buy it. That's why you're requesting it via interlibrary loan. So in that case, if you, and what it would have to be is you would have to, and this would be the requester now we're talking about, would have to make the argument that they could not afford to pay for it. So they couldn't buy it because it's only for one use and somebody needs it or whatever. But then they would have to then this is going to get complicated because they're going to have to persuade the lending library now that they can make the copy, because they're going to get involved in this whole thing too. So we're going to have what's called a direct infringement and a contributory possible infringement going on. So it's a long and short way of saying that without the proper permissions or licenses, it's highly unlikely, if there is another copy available out there somewhere, that you're going to be okay with having a lending library put it into another format and send it to the receiving library. Does that make sense?
I hope so. If the well, okay, the person who asked that question followed up. She said that the problem they have is that the DVD version is not available and they cannot find out who the copyright owner is.
Okay, so there is no DVD version.
Right.
And they can't find the owner.
Right.
Okay, that helps, because if there is no DVD version and that's the only way that the receiving library can use it, then, and they can't find the owner, they could make the copy and send it to the receiving library. What I would say in that case is they make the one copy that goes to the receiving library. They should not keep their own copy with them just in case somebody else would ask for it, because now you're making extra copies. And it should be documented exactly why that use was done. Now, if at a later date then someone comes back and says, hey, I own that, and you made an illegal copy, then you would have documentation as to what you did, and the best thing to do would be then to basically cease and desist. So destroy the copy that had been made. The receiving library would need to destroy it then, you know, and you would run the risk of actually paying royalties or a penalty in that case. Somebody would. You might want an agreement between the two libraries as to who would pay that if that happened.
Okay. All right, great. So the next question is about musical scores. Can you talk about interlibrary loan of musical scores or portions of musical scores that are requested via a fax or a scan? Are there any considerations for that?
Any considerations with musical scores? So we're talking the print, and it's being scanned and sent somewhere else.
Right.
Okay. Within that idea, if you have one, what I would say is that library who has the one copy and someone else has requested it, they could scan it and send it to the lending library. What I would tell them is, without permissions, licenses to the contrary, etc., the best thing to do with that musical score would be to delete it from the lending library's site or hard drive. So it's gone now, so that there's only the copy that the receiver has gotten. and then to follow things like put the copyright notice on it and so on. If there are any other copyright compliance rules that the two libraries follow, like you only have it for 10 days or whatever, that all that information is on it.
Okay.
Does that? But basically, yeah, you could send it unless you know, when that score was obtained, there is a license or something that says you can't do that, in which case you have to follow that.
Okay.
Mm-hmm.
All right. Well, if the person who asked that question, if you have any follow-up, just let us know. Oh, nope, she said no follow-up, so that you must have answered her questions. Thank you for that. All right. So the next question is about the rule of 5. The person is asking, she says, I was always under the impression that it was 5 from a periodical issue, but you said periodical title. Can you please clarify?
In my research, that's what I've found, that it's let me see, and I'm going to look as we're talking in another place. Okay, with a rule of 5, I found that it's okay. I want to make sure I've got this right. Okay. Okay, the lender is not allowed to send more than one copy. Okay, I'm looking. Under the CON2 guidelines, which was the National Commission on New Technology Uses of Copyrighted Works. Okay, the lender is not allowed to send more than one copy of an article from a periodical issue. It is an issue. Yes, I'm sorry, that was a mistake. It's an issue.
Okay. So
yep, she's right, or he's right.
Okay. Mm-hmm. So okay, she said thank you. So that means somebody could send out 5 articles from the January issue and then send out another 5 articles from the February issue, and there would be no violation of copyright, correct?
That is true. That is true.
Okay. All right. Okay, thank you.
I am going to circle that one, and just so that actually in my latest book, I actually have that, and I still got it wrong. This tells you how bad copyright's very confusing. So yeah, I'll fix that one on the slide before I give you the slides again.
Okay, thank you. All right, and then to follow up on that, there's another question. Is the rule of 2 for lenders and the rule of 5 for borrowers?
Well, to me it could, I guess you could look at it that both are involved with either one, but the rule of 5, you know, it's I guess both groups are going to get involved, but I guess I would say, to me, the rule of 5, you're thinking more in terms of, yeah, the borrower. But I don't think either one you can really say is just for one group, because they're all doing that. But it would be like in the case of the rule of 5, the borrower is the one that's going to be more conscious of this. Probably the lender, I don't know. I guess it depends on your records if the lenders are keeping track of that or not.
Okay.
You know.
All right. If there's any follow-up on that question, please send that along. Next question. The copyright notice that is supposed to accompany a photocopy, is there a particular version that should be used, or is there a generic version that a library can use, or does each library have to make up their own version?
There's no one particular version. It could be anything. For that matter, if you were scanning it, you could just write in pencil a C with a circle around it in 1998 or whatever the year was, and that would be enough. You know, I personally would prefer to have a nice reference or whatever down there myself, but I mean, it's just having that copyright notice. It doesn't matter how it's on there.
Okay. This question is about electronic reserves. Might need some clarification on this one.
Mm-hmm.
Electronic reserves, are they all governed by database license or something else?
Um, with electronic reserves, if you have a database that you're using and there is a license with that, that will be what you'll want to use first. It is possible that stuff on electronic reserve, I mean, it doesn't have to be with a database license. It could be that you've placed something else on reserve that was an electronic copy of something that was scanned or whatever, and then you would follow the basic law if there were no licenses involved.
Okay.
Mm-hmm.
All right. That's the end of the questions that I have, and we still have a little more time if anyone wants to jump in. Rebecca. Oh, I
I do have, I was going to say, I do have some other stuff I can start to go through if you'd like, or I can wait or not, whatever.
Well, actually, another a follow-up to the electronic reserves question. What about retention of electronic copies of articles gathered through databases from year to year for use in instructional activities? Would that be entirely within fair use, regardless of how long you keep them?
Okay, so this is where, like, let's say the faculty member has gotten something from a database, copied it off, and has it in his or her possession. Is that what we're talking about then, I'm assuming? And or do they have to give it back or whatever? Um, well, technically, once again, if it's in the license, that there's something in the license like anything copied, printed out from this database is destroyed within a year, blah, 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 then you're supposed to follow that. And that would include the faculty member. In reality, one could argue if there was one copy that the faculty member had, that as long as they maintain that one copy, they should be okay, that there should not be a problem with that. And honestly, I've not seen a license that said that, but licenses, owners can create any license they want, so anything's possible.
Okay, the follow-up is that yes, they tend to keep them, whether print or electronic, forever and use them
Yeah.
forever. So does does license then trump fair use?
Yes, it will. Mhm.
Okay. All right. She says thank you.
Mhm.
All right.
Um, just to point out, if there are no others, I'll just point out that I did have a bunch of sample questions and scenarios, and I'll just, since I see we've got 10 minutes, I'm just going to go through, like, can an ebook be ILL? That would be check your license or contract. I have some other questions. Some of them I was going to discuss. Some of them I have answers. So,
Okay.
like, if this one, if a book is missing 3 pages, can I obtain the book from another library via ILL, make copies and insert them in my library's book? And the answer is if it's just a small portion, may come under fair use. If it's a large part, let's say like of a 5-page picture book, probably not. Then you're supposed to purchase the new book. But a lot of these questions, can we legally use mass market entertainment movies obtained through ILL, let's say, or any kind of movie obtained through ILL in the school for instructional purposes is yes. Um, are librarians responsible for how ILL material is used by patrons? The answer is not really. However, it is feasible that if an owner thought their work was being misused, that in let's say, a cease and desist letter that they might send to the patron, the library or librarian could feasibly be named as part of this, as like they have to cease and desist whatever part they had in it as well. But librarians, obviously, once it's out of your hands, you don't know how it's being used. But that's where we get into that whole concept again of contributory infringement. So there could feasibly be something going on there. This next question deals with orphan works and digitization. And basically with any orphan work, I touched on it earlier, but always conduct a reasonable investigation. You're trying to find the owner of the work. Then if you can't find that owner, it's feasible you can digitize the work. But if the owner is found, you may have to pay reasonable compensation or stop using the work. And again, whether this is probably on the receiving library in the case of ILL, but one could argue that anyone could get involved. So just some things to think about. These others are just examples where you follow copyright law if there are no licenses. So here's one about showing, can you show something you obtained via ILL over a closed circuit system to the entire school? Well, if you're in a school and it's for an educational purpose, yes, you can. So there are actually ways to work within the law. It's not like everything's no, 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 but it's just knowing enough to be secure with what you're doing with some of that. This is a similar one. Can you show an educational film to more than one science classroom at the same time? The answer is if it's for an educational purpose, yes, you can. So, and I'm looking at the clock and trying to go pretty fast here, but if you have an electronic toolbox and you want to create graphic novels and put it up on a website, I use school, but it could be any website. Some materials found in the toolbox were obtained via ILL. Is doing this legal? Again, that's going to depend. It would depend on the license of the material borrowed and what the licenses were for that. Basically, when you're doing something and putting it up on the web, where if it's open to the public, if it's an internet, not an intranet, if it's something where it's not locked in, there aren't these things that lock it for only a specific group to see it, for instance, you do need to be pretty careful that you have obtained it legally and that such use would be legal. Can you, and this one does work with that derivative work thing, can you digitize a version, let's say, of a movie and put it, that you obtained through ILL, and put it up on the web? Because it is a derivative work. And again, that one is, I have a flow chart in one of my books. The flow chart is not on the slide, but what I will tell you is I did include in the handouts, there's sort of a generic flow chart, and there are certain things you need to follow and ask of each item if you're thinking about doing something like that, and that can basically help you. It gives you an idea of whether it will work or not. And for instance, let's see, I'm looking for this one. If you're digitizing a program, let's say, you'd need to know, does it fit under fair use? Is it in the public domain? Has it been changed from the original version? You know, do you have permission? Did you purchase a license? And so on. So you'd have to answer those questions, and then it may or may not work. So this next one deals with lip dub videos. So I've just tried to pick a variety of things. This one, if the songbook in this case came through interlibrary loan, again, you have to look within certain permissions and so on. So, and ask the different things. Does it fit under fair use, etc. So now I will ask once again, are there any other questions, concerns?
No, I have not seen any more come in, so must have answered everything, or I've been very thorough. And I think it was helpful to have some of those other questions and scenarios at the end too, you know, so. All right, so I think we'll go ahead and wrap up. Thank you so much, Rebecca, for your time today.
You're welcome.
And all that great information. And thank you to everyone who joined us. Again, I'll just thank Rebecca for letting us record the webinar and share her materials. We will get that up onto the Rails CE archives page as soon as possible. And everyone who registered will get an email alert when that's ready to view. So thanks, everybody. Have a good afternoon.
Okay, and Louise, are you
Yeah,
still there?
I am, but everybody can hear us, so hold on.
Oh,
Um,
okay.
so
Well, I was just going to say, I thought my internet was off. It was not. So I apologize for a couple, like that sound, which I'm sure you all got. I apologize for that.
no, it was fine from this end. So thanks, Rebecca.
You're welcome. And I will fix that slide on the rule of five, and then I'll send it to you via email. How's that? And so you can put it up.
Sounds great.
Okay, thank you.
Okay, thank you. Bye-bye.
Bye.